Okay, Mr. Meadow. Mr. Meadow, can you hear
Yes,
me?
ma'am.
Okay. Tell me,
Yes.
are you based in Windhoek?
No, I'm still in Germany.
Okay. Um, because it seems you're the only student that is taking this course seriously, um, and has logged into the class. So I'm thanking you for this, and I want to give you some value for your time. But on the other hand, you will also understand that I'm not particularly inclined in teaching like a full uh, lecture, a couple of hours lecture session for just one student. Um, so what I'm going to do for you, just to like make it worthwhile and like reward you, is I'm briefly just going to go through the assignment,
Yes, ma'am.
and just sort of point out in the various questions uh, where what you should focus on, where you can, in which parts of the study guide you should look for the answers and what you must include, that type of thing, just to guide you through this. Um, and then I want to offer to you, if you want to, then rather spending time in a class this morning, sit down and prepare a draft version of your assignment,
Oh, okay.
and email it to me. You have my email address?
Yes.
Okay, so prepare a draft version of your assignment, and email it to me, and I will go through it for you.
Oh, okay.
And not fix it. I'm not going to do it for you, whatever. Of course, it still has to be your own work. Otherwise, you're not going to learn. But I will go through it for you and guide you. Tell you, okay, you need to add more of that. Constant, what about that? Whatever. Uh, before you finalize it, then before you for submission, to make sure uh, you get good results in your assignment. Would that be okay for you?
Yes, that's perfect.
Okay. But I'm not just going to log off right now.
Yes.
I'm just going to, if, do you have the assignment with you?
I do have it here, soft copy.
Okay. So I'm just quickly going to basically run through it and just give you some pointers before you start with it.
Okay.
Okay, so question one. Oh, by the way, I noticed this morning when I sat down to start sort of straightening out my mind for the class, I noticed that the total actually adds up to 60 marks, not 50 marks.
Oh, okay.
But do everything, and the final percentage will then be calculated out of 60, not out of 50.
Oh, okay.
Just makes my maths more difficult, but it
Yeah.
gives you a better opportunity to get marks.
Yes.
Okay, so question one then is really straightforward knowledge items. And please, Mr. Meadow, do this assignment on your own.
Yes.
But you're the type of student that will, you're not going to try to Google or ChatGPT or anything. You're not that type of student. Um,
Yes.
but all these answers, all the answers for all the information you need for the assignment is in the study guide.
Okay.
Uh, do you have do you have the study guide?
Yes, I also have it here, soft copy.
Yeah,
The
because
study.
all yeah, okay, yeah, okay. Now, as long as you have it, because it is on e-learning, the PowerPoint slides that I used uh, when I was still teaching this course face to face for full-time students, the PowerPoint slides are also on e-learning. So you can also go and look at them to just sort of help you clarify the work. But really, everything you need is in the study guide. I know I say in big letters, do not copy directly from the study guide. students tend to stress about that. This is law.
Yes.
When I say don't copy directly from the study guide, I do not mean you have to change each and every word. Because the legal terms, the guarantee against eviction, for example, is called the guarantee against eviction. You don't have to use different words for that. It's like trying to change your name. Your name is Pythia. You don't have to give yourself a different name because I said don't copy. So I'm not, what I mean by don't copy directly from the study guide, I'm not saying you may not use a single word that is in the study guide, because that would just be silly. What I'm saying is try, when you copy, if you take something from the study guide, at least try to understand what you are writing. Let's
Yes.
see here, question 1.6. Briefly explain the passing of the risk rule. I'm going to just find the place here. That's at the bottom of page 15 of the study guide. It's about 1, 2, 3, 4. You don't have to look now. You can, and I'm also recording this for if you don't remember. I'll also send you the recording. So make some notes now, but you don't have to try to write down everything I say. I want to illustrate the point. The passing of the risk rule, the answer to that question is at the bottom of page 15, top of page 16. But if you start off writing, if you copy word for word, the passing of the risk rule is unique to a contract of purchase and sale. This rule states that from the moment that the contract is perfecta, the risk will pass to the purchaser. Now you're copying. Now you're not using your own words. But this rule states that is direct copying without actually giving context. Why should you say this rule states that? Start off with the passing of the risk rule is, or something like that. The essence there is that from the moment the contract is perfecta, the risk passes to the purchaser. Not that words, this rule states that. Do you understand what I mean?
Yes, ma'am.
So I'm just trying to illustrate to you what I mean by do not copy directly from the study guide. So don't take the whole sentence and just blindly write it down. Especially seeing that you've actually got the study guide in soft copy. So it's become easy for students just to do a copy and paste. But if you just copy and paste, and you get to the exam and I'm asking you to explain the passing of the risk rule, you're not going to be able to do that. Whereas if you've actually sat down and read the sentence and thought to yourself, what does this mean? Then you're going to remember it. And when you write the exam and I ask you that question, then you're going to be able to, you'll get the marks. So that's the only reason why I'm so strict about don't copy from the study guide. It's not because I'm nasty or anything. It's literally because you don't learn if you're just blindly copying and pasting without actually reading the words. So yes, okay, so that the answer to that question. You can find then on page 15. So whole of question 1 is short knowledge-based questions. Nothing particularly difficult. Question 2 concerns the guarantee against latent defects. Guarantee against latent defects. Let me just find the correct unit there. That is Unit 4. Unit 4 concerns the guarantee against latent defects. The seller has the duty to guarantee that the thing sold does not have something wrong with it, that does not have a latent defect. But in order for the purchaser to be able to rely on this duty, the purchaser needs to prove that there was a latent defect. Not a patent defect, not something that broke afterwards, whatever. The purchaser, in order to rely on the guarantee against latent defects, must prove that at the time when he or she bought the object, it had a latent defect. What must the purchaser prove? Bottom of page 19, top of page 20, those 5 requirements. In order to do question 2, for each of these short scenarios, you have to check whether the facts in that scenario matches all 5, not just 1 or 2, all 5 the requirements for a latent defect. Let's look at 2.1. P buys frozen fish from S. P leaves the fish in his hot car while he completes his shopping. After eating the fish, P is hospitalized with food poisoning. So is this a latent defect? Start looking at your requirements. The very first requirement is the latent defect is a defect which existed at the time of conclusion of the contract. What happened here? He bought the fish, he left it in his car. It went bad. Is this a latent defect? Try that,
Yes,
Mr. Meadow,
ma'am.
try that one. Think carefully. The requirement is it must have existed at the time of conclusion of the contract. So when he bought the fish. Now he buys the fish and he leaves it in the sun in his car and it goes bad.
Oh, yes.
Is this a latent defect?
No.
It's not a latent defect. So how would you answer that question? By saying, no, it's not a latent defect. He doesn't have a claim. Why not? Because, and remember, when you motivate these types of questions, a motivation consists of a statement of law, not repeating the facts. So your motivation is not going to be, no, it's not a latent defect because he left it in the hot car. Your motivation is going to be, no, it's not a latent defect because it did not exist at the time of the entering into the contract. Are you with me?
Yes, ma'am.
Okay, I see we have one more lost soul. Vicomberero, hope I pronounced that correctly. Vicomberero.
Yes, yes.
Is that correct? Did I pronounce your name correctly?
Yes, it's close.
Okay, great. Yeah, so now I have 2 students in the class. What I'm doing at the moment, Vicomberero and for Ms. Meadow, because she was the first student, the only student that joined initially, is I'm just going briefly through the assignment, giving you some pointers, what you should concentrate on, how to approach your assignment. Then I want you to do your assignment, do a draft of your assignment, and before you submit, if you want to, you can email it to me. Or I prefer email, but even WhatsApp if you want to. Send it to me, and I will look through it and give you feedback before you submit, to make sure you get good marks. So what I'm going to do now, seeing that we now have 2 students, just give me a second. I'm going to share my screen. Just confirm quickly that you can see the screen. It's literally just a white page. There's nothing on it. I'll be typing on that. But can you see the white page?
Yes, ma'am.
Yes, ma'am.
Okay. So I'm just going to make some notes as well. I'll also save this and send this to you. So I'm going to make some notes. So question 2 is unit 4. Bottom of page 15. What you need to do for all, 1, 2, 3. So my numbering is wrong there as well, but just correct the numbering. For these 5 scenarios, question 2, this type of question is what we refer to as structured application. And in your exam at the end of the semester, you will definitely have structured application questions as well. So structured application requires a yes or a no plus a motivation. And as I've just explained, the motivation is you refer to the legal principle applicable. It's not just a repetition of the facts. So you don't just copy the facts again. You must give me the legal principle. Let's do another one. This is 2.2. P buys a house from S. There are obvious brown water stains on the ceiling. So if he walks into the house and he looks up at the roof, it looks like my ceiling in my house that I'm looking at the moment. There are big brown stains, obvious brown stains on the ceiling. After the first rains, P discovers that the roof leaks. Now, what are the requirements for a latent defect? The requirements, as stated, bottom of page 19, top of page 20. Sorry, it's page 19, not 15. Top of page 19, it existed at the time of the conclusion of the contract, renders the thing less useful or effective, so serious that the reasonable person would not have bought it. is not visible or perceivable by the precise person and was not known to the purchaser. Now think about this one quickly. These requirements. He walked into the house before he bought it. He saw that there were water stains on the ceiling. And when it rains, he discovers that the roof leaks. Is this a latent defect?
Sorry, excuse me, ma'am. Can you just please repeat? Kind of lost.
The requirements for a latent defect is it must have existed at the time of conclusion of the contract, renders the thing less useful, so the thing can't be properly used for its purpose, is so serious that the ordinary reasonable person would not have bought the thing. So you're not just talking about a slight scratch, you're talking about a serious defect. Is not visible by the precise person, so you can't see it, and is not known to the purchaser, so the purchaser did not know about it. Those are the requirements. The case study says he walked into the house, looked up, and there were brown water stains on the roof. And at the first rains, he discovers that the roof leaks. Is this a latent defect?
Yes, ma'am.
Now think carefully, think carefully. I'm going to repeat just these last two requirements again. In order for something to be a latent defect, it must not be visible at the time of buying it. So you cannot see it. And these two go close hand in hand. You don't know about it. He looked up and saw there were brown water stains on the roof. Can he claim that he didn't see it or that he wasn't aware of it?
No. I mean,
No,
yes.
No. Be careful now. He bought this house. He could see they were obvious. They weren't hidden. There were obvious water stains on the roof. Could the purchaser now turn around and say, but I didn't know the roof leaks?
No.
No, the purchaser can't do that.
Exactly. So it's not a latent defect. What is your motivation? Your motivation is not going to be that there are obvious brown stains on the ceiling, because that's repeating the facts. The motivation can be is the stains. You can say the stains, or you can say the defect was visible. He could see it. So a motivation, not just copying the facts, but referring me to the relevant legal principle. Let's look at 2.3. Purchaser orders a silver cell phone from Phones R Us. When the phone is delivered, it is white, not silver. Is this a latent defect? The requirements for latent defect, just going to read the relevant one, not all 5 of them. Order for something to be a latent defect, it must be this defect, this problem with the thing must be so serious. No, sorry, that's the wrong one. Let's go to that, use that one as well, but rather let's use this one. In order for something to be a latent defect, the defect must render the thing less useful or effective. So as a result of this defect, you cannot use it for the purpose that you want to use it. Now, the purchaser ordered a silver cell phone and got a white one. Is this a latent defect?
I'd say it's not a latent defect.
It is not a latent defect. Why is it not a latent defect?
Because it still can be used as a phone even if it's a different color.
Absolutely. The color, the different color, you might not like it as much, but it doesn't render it less useful. You can still use it. It is still useful. So absolutely. So what do we have here? No, it is not a latent defect. It is not less useful. Or your words that you used are perfect. He can still use it. See, you can use, also note what I'm doing here. I don't have one answer that you have to have those precise words. It is not less useful. That's a correct answer. Your words were, he can still use it. That's also a correct answer. Okay, Mr. Meadow is on hold, but never mind, I am recording. So I'm going to carry on then. So question 3. Question 3, Miss Holly. Miss Holly sells a second-hand car and delivers it. Couple of weeks, 2 weeks later, Mr. Dowsett pitches up there and says, no, but this was a stolen car and you must give me your car back. Or give me the car back. Mr. Morkel is very upset about this and approaches you for legal advice. Advise Mr. Morkel of his legal position and what he's required to do. This question concerns the guarantee against eviction. So to get maximum marks for this question, you must firstly tell me what this question is about. So you literally start off by saying, this is about the guarantee against eviction. Then you explain to me what the guarantee against eviction is. You'll find that under paragraph 6 on page 12. So the guarantee against...
Sorry, ma'am.
Yes?
I seem to not have been added on Teams and enrolled on e-learning. Is
okay.
that where the study guide is?
The study guide is on e-learning. Yes, all the notes and all the notes, as well as the PowerPoint slides, are on e-learning.
Okay.
It's very important for you to, you must only when let's try your name again. Vikomberero.
You can just use my surname, it's easier.
Yeah, but I like practicing my pronunciation. How do you pronounce your
Okay.
surname?
Ngove.
Ngove.
Yes.
So you pronounce the N.
Yes.
Okay, I'm never sure whether to leave the N in or pronounce the same Ngove. I'll settle for Ngove then, Miss Ngove.
Yes.
When you prepare this assignment, you
Mm-hmm.
use only the notes. You don't
Okay.
use anything other than the notes. You don't Google.
Okay.
You use only the notes. I will, after this session, please just send me a private message on WhatsApp so
Okay.
that I can just enroll you on e-learning to make sure
Okay.
you have access.
Yes. Okay.
Yeah, okay.
Thank you.
So, um, so you need to explain then, you tell me this question is about the guarantee against eviction. You explain what it is. Automatically forms part, it's included in every contract. It automatically forms part of a contract of sale. And the meaning, what is the guarantee against eviction? The seller undertakes to give the purchaser undisturbed possession of the thing, ensures that nobody with a better right to the thing will take the thing away from the purchaser. In other words, that the purchaser will not be evicted. Before we changed, before you joined the class, I spoke briefly about direct copying from the study guide. The assignment says very clearly, use your own words. Do not copy directly from the study guide. That does not mean, Ms. Ngove, that you have to change every single word. The guarantee against eviction, that is a legal concept. You're allowed to use those words. You don't have to use different words for that. What I mean by direct copying, like if I read from the study guide here, it says, in other words, that he/she will not be evicted. Now,
Excuse me, ma'am.
yes,
So even with a little bit of paraphrasing, it's also not allowed?
no, you have to paraphrase. I want
Okay.
you to paraphrase. That's what I'm trying to explain, that you must paraphrase. Don't copy. So don't write that he/she has not been evicted, because you're dealing with a case study. So it's either a he or a she. It's not a he/she. That, but if you write like that, then to me, that's a dead giveaway. You're doing a copy and paste from the study guide. Do you understand what I say? Are you following me?
Yes, ma'am.
So, but yes, use the study guide, paraphrase, but you paraphrase, do not use a paraphrasing tool. Don't feed it into AI and ask them to paraphrase, because they change words, substitute words with random synonyms, and you get utter nonsense. You must paraphrase the study guide, but you don't have to change every single word. It is okay to use, so don't stress too much about this that I've said, that answers that are copied directly from the study guide will not be marked. You are allowed to use the legal terminology, but paraphrase. But back to answering the question, you have to identify that it's the guarantee against eviction. Explain what the meaning of this guarantee is. And then you need to explain what must the purchaser do. There are certain rules that a purchaser needs to follow in order to be able to rely on the guarantee against eviction. These you will find at the bottom of page 12. top of page 13. So you need to list these rules. You need to list these rules. They are, the way they're written in the study guide is fairly lengthy. Paraphrase. Basically just the actual rule is in bold in the study guide, and the rest is just like a further explanation. So if you've done that, that will give you 10 out of 10 for that question. So you start off by telling me that there's a guarantee against eviction. You explain what this guarantee entails, what it means, and then, because the question asks, advise him of his legal position, so you tell him that he's got the guarantee against eviction. You explain to him what this guarantee means. The question says, what is required to do in order to protect his interest? Those are those three rules. He must do this, this, and this. He must keep the thing in his possession. He must conduct a strong defense, and he must notify the seller of the eviction, of the threatening eviction. If you've got all of that in your question, you have 10 out of 10. Questions?
No, ma'am.
Mr. Meadow, are you still with us?
Yes, ma'am.
Okay, question 4 then. Question 4 concerns credit agreements. Just want to find this. Okay, before I get to Unit 6 for credit agreements. You do not have to study in detail. Gives you a whole lot of definitions from the Credit Agreements Act, which you don't. Those definitions are fairly lengthy. I will not ask you to write down those definitions in the exam, so don't stress about that. What you do need to know, the difference, page 29, the difference between suspensive conditions. So just look at that, but for the rest of that unit, those transactions those definitions are quite lengthy. You don't need to stress about memorizing the definitions. In order to do question 4, answers to question 4 can be found in Unit 7. Now, the way the Credit Agreements Act is written is there are Credit Agreements Act contains certain prohibitions, certain things that may not be in a credit agreement. And this is what question 4 is all about. Like these things that are in here. May this be in a credit agreement or not. So let's look at the first one, 4.1. Peter and Embassy Motors come to an agreement that Peter can trade his own car in instead of paying a deposit. So what is the question there? 4.1. Answer to that you'll find in paragraph 3 on page 34. If you read paragraph 3 on page 34, it says that the credit agreement it starts off by saying that if you enter into a credit agreement, you must pay a deposit. It's also referred to as an initial payment. Then it says, the credit agreement may trade in goods as a deposit. Credit receiver, so that's the purchaser. The credit receiver, the purchaser, may trade in goods as a deposit. The question is, the purchaser and the purchaser and the seller agree that the purchaser can trade in his own car instead of paying a deposit. Is that legal in terms of the Credit Agreements Act? Come, work with me here. For each of these questions in question 4, you have to compare the scenario with the Credit Agreements Act and tell me, is this legal? Can this be done or not? So the first one is he buys a car, but instead of paying a deposit, he trades in, agrees that he will trade in his own car. The Credit Agreements Act says a credit receiver may trade in goods as a deposit. So is it legal for him to trade in his own car? Yes or no?
Yes.
Yes, ma'am.
Yes, it is legal. Motivations always referring to the law, not to the facts. So yes, the purchaser so you will be finding your motivations in the study guide, not in the assignment. You're not going to be repeating the facts in the assignment. 4.2, Peter did not sign the assignment, or sign the agreement. Formal requirements for a credit agreement. Find those in paragraph 1 on page 32. The first formal requirement is every credit agreement must be in writing and signed by or on behalf of the parties. But now the question is, what effect does this have on the credit agreement? These formal requirements, if you go up a little bit and you read carefully, it says there are certain formalities that have to be complied with. Failure to comply with the formalities does not make the agreement invalid, but non-compliance is a criminal offense. I'm going to type that out here because you might not have the notes in front of you. To comply So that's what the act is. Failure to comply with the does not matter, but it's a criminal offense. So 4.2 says the requirement, the formal requirement is every credit agreement must be in writing and signed. Question 4.2 says he did not sign. So what is your answer going to be? You must discuss the legal position. You must tell him what is the consequence of this. How would you set about answering that question?
The contract between them is not valid because he didn't sign.
Okay, Pethia, look carefully. He didn't sign, you correct. But look carefully at what I said here. Failure to comply does not make the agreement invalid, but is a criminal offense. So rethink your answer. He didn't sign, he didn't comply with the formalities. What is his legal position?
It's a criminal offense.
The agreement is still valid.
The agreement is still valid, but it is a
Yeah.
criminal offense.
Did not comply the T's, the is valid, but it is a criminal offense. Okay, so 4.3 and 4.4, you will also find in Unit 7. You carry on in the same manner as what I illustrated there. In each instance, read the study notes carefully. See in the study notes what is the requirement. Did the parties adhere to this requirement? And what are the consequences? So what is the requirement? Are the consequences? In terms of the act. So for 4.3, that's what I'm looking for. Then question 5, not complicated at all, concerns lease agreements. So that's Unit 10 and Unit 11. Just looking for the correct place here in my study guide. Okay. So 5.1 during June 2024. Okay, so there was a lease agreement. Then this chap is unable to pay his rent. So he's in arrears rental. Is Steve's landlord entitled to attach a computer which doesn't belong to him, but it's on the premises, in order to sell it to recover for the arrears rental? So the crux of this question, it concerns the landlord's tacit hypothek, the lessor. Lessor is also the landlord. Concerns the landlord's tacit hypothek. So you'll find that in Unit 10, paragraph 3. And specifically, the issue in this question is, the question asks, can he attach this computer? The issue is that so can he attach the computer? The issue here is the computer is on the premises, but does not belong to Steve. So the question is, can the landlord, in terms of the landlord's tacit hypothek, attach the computer, attach the property of somebody else, so that belongs to something else? Answer you will find there in paragraph 3.1. Things subject to the lessor's hypothek. So what can be attached? The requirements are that movables of third party, okay, first let's go up one sentence. Attaches to movables that are on the lease premises. Movables that are on the lease premises. So in this instance, look at the facts. Where was this computer? The computer was on the lease premises. Second question, movables of third parties are subject to the hypothek if they were brought onto the premises with a third party's consent. So belong to, just notice here, even while I'm typing, I'm paraphrasing. Instead of saying movables, I'm saying things. Just giving you an illustration of paraphrasing, not copying directly from the study guide. Things that belong to somebody else can be attached if they are on the lease premises with the owner's consent. His computer belongs to his brother, but he was using it for his business. So I think we can gather that his brother allowed him to use it. And if the owner, so not Steve, not the tenant, the owner of the the goods did not inform the landlord So the duty rests on the owner of the things, on Steve's brother, to have informed the landlord, not when he wants to attach the things in advance, when the goods were brought onto the premises. Those two requirements are not met, the landlord can attach the goods. So the question is, can the landlord attach these goods? In terms of the landlord's tacit hypothec, he can attach anything, all movables that are on the lease premises. Things that belong to somebody else can be attached if they are on the lease premises with the owner's consent and if the owner did not inform the landlord. So if Steve's brother did not inform the landlord in advance, the landlord can attach these things. Are you with me?
Yes, ma'am.
Yes, ma'am.
Okay, and then last question is just 3 little marks. So time passes. Steve business recovers. He continues to pay the rent. And then when the formal lease agreement expires, he just continues. He doesn't move out. He stays there. He continues to pay the rent. And the landlord continues to accept the rental. So 5.2, answer to that you will find in Unit 9. If I can just find it there. No, I'm wrong, sorry. Not Unit 9. Unit 9 is termination. This is about, oh yes, it's Unit 9, renewal of a lease. Paragraph 5. Renewal of the lease. What happened here? The lease agreement expired. He remained on the premises, continued to pay rent. The landlord accepted this rent. So on page 54, you're going to find the answer to that. A tacit relocation is an implied agreement to relet and is concluded. So what happened here is the lease was renewed. By way of a tacit relocation. And then just explain briefly, just very briefly, not a whole page because it's only 3 marks. There you are. And that's your entire assignment. So what I'm suggesting you do now is go and do your assignment with this still fresh in your memories. Ms. Gove, please just send me a WhatsApp so that I can add you to e-learning so that you can access the notes. Prepare a draft of your assignment and send it to me so that I can look at it for you before you submit, so that you can get good marks and give your semester mark a nice boost to ensure your future success. Thank you so much for making the effort to join the class. It's a bit disappointing that there were only 2 students in the class. Mr. Kasutu did contact me in advance and say he cannot, and can I please record the class for him, which I did do. So Mr. Kasutu at least also made the effort to contact me. The rest of the students just absent and silent, but disappointing. If you have any questions about the work, either of you, please ask questions. If it's work about content matter, ask the questions on the WhatsApp group, so that we can also use the WhatsApp group as a teaching tool. Thank you so much for joining. Have a lovely weekend further.
Thank you. Same to you, ma'am.
Thank you. Likewise, ma'am.
Bye.
Bye.